Good morning, everyone. Welcome to Assembly Judiciary. Good morning, everyone. Welcome to Assembly Judiciary here in Carson City and there in Las Vegas, as well as anyone watching online through the YouTube Legislative channel or through Nellis. With that, Committee Secretary, please take the roll.
Assembly members Cole, Dahlia, Gonzalez, Gray, Hanson, Hardy, LaRue Hatch, Marzola, Moore, Nadeem, Orentlicker, Roth, Urick, and Chair.
Here, and please mark Assemblymember LaRue Hatch present when she arrives. Just a few housekeeping issues. Please make sure that you turn down any sounds on your electronic devices. Also, today's meeting ID, if for those choosing to call in to testify or make public comment at the end of the meeting, our meeting ID today is 890-865-98112, and the phone number is 1-888-475-4499. We will have 3 bills today. We will take the bills in order, and we'll have public comment at the end. Again, I ask that presenters keep your presentations to 15 minutes, and anyone making public comment or testimony, keep your remarks to 2 minutes. Also, the first time you speak, please make sure that you state your name and spell it so we have it correct for the record. And with that, we will go ahead and open Senate Bill 203, which revises provisions relating to the pari-mutuel, mutual it is, okay, system of wagering. And with that, Senator, your bill hearing is open, so whenever you are all settled and ready, you may proceed.
Thank you so much, Chair Miller, Vice Chair Marzola, and members of the Assembly Committee on Judiciary. For the record, my name is Julie Pizzina, and I represent Senate District 12 in Clark County. Today, I'm here to present Senate Bill 203 alongside Virginia Valentine and Mark Rubenstein, which revises provisions related to the pari-mutuel system of wagering. So the question I've gotten asked most frequently with this bill, and it will shock none of you, what is pari-mutuel wagering? It's a betting system typically employed for off-site betting on horse racing, where all bets on a particular type are placed together in a pool. Taxes and the house take are deducted. Payoff odds are calculated by sharing the pool among all the winning bets. Pari-mutuel wagering works by aggregating all wagers into a common pool and then using that money, minus a commission for the track, to pay the winners. Unlike fixed odds betting, pari-mutuel wagering involves frequent odd changes as the action flows toward or away from individual horses. In Nevada, off-track pari-mutuel wagering is governed by Nevada Revised Statute, Chapter 464, and Nevada Gaming Control Board Regulations 26A and 26C. The Nevada Gaming Commission appoints the Off-Track Pari-Mutuel Wagering Committee, and it consists of 11 people who are licensed to engage in off-track pari-mutuel wagering. Upon their appointment, the committee is granted the exclusive right to negotiate agreements relating to off-track pari-mutuel wagering with persons licensed or otherwise permitted to operate a wagering pool in another state where the race occurs and persons licensed in Nevada as an operator of the system. Senate Bill 203 provides the State of Nevada, the Nevada Gaming Commission, the Nevada Gaming Control Board, the Off-Track Pari-Mutuel Wagering Committee, and certain other persons immune from civil liability for any decision or action taken in good faith and without malicious intent to carry out the provisions of law relating to the pari-mutuel system of wagering. It's necessary to protect individuals making decisions within the system and encourages effective regulation without fear of personal legal repercussions. Additionally, this bill modernizes provisions relating to the broadcast, dissemination of certain sporting events, and the regulation of the pari-mutuel system of wagering. To go into a lot more detail on this bill, I'm going to hand it over to the experts. So first up, we'll have Virginia, and then I will hand it to Mark, and I thank you all so much for your time.
Thank you. Good morning, Chair Miller and members of the committee. My name is Virginia Valentine, Valentine, and I'm president of the Nevada Resort Association. I'd like to thank you all for the opportunity to be here this morning. And I'd like to thank Senator Pizzina in particular for sponsoring the bill and understanding why this is an important matter for the industry. And you're going to hear more about that because we're at a really critical time here. And without this bill, we wouldn't be able to have the successful continuation of racebooks in the state. The timing of this bill is also apropos, given that this weekend is the Run for the Roses, a time when horse racing and really big hats capture the nation's attention. The 151st Kentucky Derby takes place this Saturday, which means Nevada's racebooks will see their biggest action over the weekend and over the next few weeks for the 2025 Triple Crown. And why these Triple Crown races tend to be the most well-known, there are horse races all year round that bring fans to racebooks across Nevada. Horse racing has a long history, starting in our state in 1915. The Nevada Racing Commission was established to recommend rules, regulations, and conditions under which horse racing could be conducted and to inspect books of racing associations. Today, the Nevada Gaming Commission handles this responsibility. In 1949, Nevada legalized sports betting and horse racing, and the first sports and race book facilities quickly opened. Today, there are 170 licensed race books in the state, according to the Nevada Gaming Control Board's latest abstract report. Race books brought in more than $32 million in revenue for fiscal year 2024. While sports betting receives a lot of attention, there's a healthy market for horse racing. In fact, placing a wager on a pari-mutuel racing is an experience that many visitors want to experience during their visits, especially in Las Vegas. Our members view it as an important amenity for guests, as a loyal following of regular customers who enjoy playing the ponies. It's an expected option at sportsbooks and one that our members see value in providing. And now I'd like to turn it over to Mark Rubenstein to go through the details of the bill.
Good morning, Chair Miller and members of the committee. I'm Mark Rubenstein of the law firm of Reed, Rubenstein and Bogatz, appearing in support of this bill for the Nevada Resort Association and Nevada Pari-Mutuel Association. That's MARCRUBINSTEIN. First, I'd like to offer my thanks for my concurrence in the remarks of Senator Pezzina and Virginia Valentine. I'd also like to expand on them a bit in the hope that it becomes more apparent that what these proposed amendments are attempting to accomplish and what is driving them. Let me begin with Section 2 of the bill, which is the immunity provision. The intent of this language is to provide immunity from civil liability for the 11 members who are appointed to serve on the Off-Track Pari-Mutuel Wagering Committee, which is often casually referred to as the Rate Committee. This committee was created more than 30 years ago by the legislature as part of the regulatory framework for off-track pari-mutuel wagering in Nevada. The committee is appointed and overseen by the Nevada Gaming Commission and serves two functions. One, to negotiate on behalf of the Nevada race books with out-of-state racetracks to determine the fees to be charged to the books for including their pari-mutuel race wagering in the pari-mutuel wagering pools at the tracks. And two, to negotiate on behalf of the books with the off-track pari-mutuel system operator, which is often casually referred to as the Nevada Hub. The system operator, which is the focus of the other proposed amendments in this bill, essentially aggregates all of the off-track pari-mutuel wagers made in Nevada, transmits those wagers to the respective wagering pools at the tracks, and also provides accounting and reconciliation services for the Nevada books once the outcome of the wagers are determined. It's important to note that the committee does not have any functions whatsoever other than the two just described. It's also important to note that nothing the committee does impacts consumers, in this case bettors, or their relationships with the Nevada casinos. The purposes of creating the Off-Track Pari-Mutuel Wagering Committee as an instrument of the Gaming Commission were threefold. First, it provides a mechanism for all the books, large and small, urban and rural, to pay the same rate or fee to each racetrack, so no Nevada race book is put at a competitive disadvantage. And the committee's selection criteria also try to make sure the smaller books are fairly represented. Second, it puts the books as a group on more equal footing when it comes to negotiating with the racetracks, which have exclusive control over their products, and with the system operator or hub, which effectively has a monopoly over what it does. Finally, the existence of the committee is intended to help protect the Nevada racebooks from the threat of antitrust litigation for what otherwise could be considered a cartel, by creating a body under state supervision and control that would meet the criteria of the state agency exemption to the antitrust laws. The reason for the proposed new language in Section 2 of the bill is to go a bit further than that and protect the members of the committee by providing immunity from civil liability for their work on the committee. It's important to note that the people who serve on the committee on behalf of the companies they represent are all volunteers. Typically, racebook directors or managers or other casino executives who are asked by their companies to exercise their rights as members of the committee and participate in negotiating process with the tracks and the hub. Committee members do not receive any compensation for their service. The committee does not receive any funding from the state, nor does the committee have any of the legal or contractual protections that corporate or charitable organization boards have. That is, the members of the committee are not indemnified by the state for their service, nor is there any insurance afforded them. As a result of events that occurred over the past several years involving an out-of-state racetrack owner and operator that also controls several other racetracks, there was a very real threat of antitrust litigation against the state, the Gaming Commission, the Gaming Control Board, and the committee. And while we are confident the state and its agencies and the committee would prevail in such litigation under the state agency exemption, the cost of defending such an action would be enormous. To ask committee members to participate in the defense of such an action, or worse yet, to defend an action where they were the only named defendants, would be terribly unfair and unreasonable under the circumstances. And providing the requested immunity costs the state nothing. As mentioned, the committee's functions are limited and do not impact bettors or their relationship between bettors and racebooks. Thus, the reason for including the immunity language in Section 2 of this bill. For reference, the language is an almost verbatim copy of the provision that exists in Chapter 462 of NRS, which is the chapter that sets forth the regulatory framework for charitable lotteries. The only new language in this version is the addition of the committee to the other bodies receiving immunity, as there's no corresponding body to the committee in Chapter 462. That concludes my remarks on Section 2 of the bill. Would the chair like me to stop here and answer questions on this part before moving on?
No, we will complete the bill presentation and then we'll ask questions. You all have about 3 minutes left in your presentation.
Okay, I'll try and fly through this. The second part of this bill covers all the amendments other than Section 2. The proposed amendments accomplish the following. First, they collectively eliminate the need for a racetrack to enter into an agreement with a disseminator in order to furnish live broadcasts or the results of races at the track. Instead, they would be able to enter into agreements directly with the books, subject to the requirement that all books must be offered the live broadcasts on the same financial terms. Second, as part of the foregoing changes, they propose to repeal provisions that required competing disseminators to make a proposal for live broadcasts. There hasn't been a competitive bid on live broadcasts in the last 15 to 20 years, and so those provisions are obsolete. Third, they eliminate the requirement for there to be a licensed disseminator in order to provide information regarding entrants and results. As this requirement is also obsolete, as the information concerning these races is now widely known and not vulnerable to interception by unsuitable persons as it was when the disseminator laws were enacted. It's important to note nearly all the provisions in Chapter 463 of NRS affected by these amendments do not apply where the Nevada books have entered into an agreement with the track for off-track parimutuel wagering. So the impact of the statutory repeals is minimal on both racebook operations and regulatory oversight. Nonetheless, they're important because they facilitate the acceptance of wagers outside the parimutuel system, which some books still offer, and they also are tied to what's attempted to be accomplished with the amendments to Chapter 464. And basically, these amendments are twofold, and these are very critical. Number one, they change the requirement for a hub operator to be licensed. Instead, the hub operator will be registered as a service operator, a service provider, which is really more apropos for the function that the hub operator performs. And second, they eliminate the requirement that the hub operator be located in Nevada so long as both the system and the operator are physically present in a state or foreign country where they've been licensed or approved by a regulatory authority. This is crucial because there is only one hub operator in operation in the state of Nevada and has been for many years. It is not likely to bid on the contract when it expires, and therefore the only prospective replacement are situated outside the state of Nevada. Finally, although it's changed to Chapter 463, Section 1.8 of the bill adds the defined term operator system of a system to the list of service providers in order to accomplish the registration process.
Okay,
I'm
Yeah.
done. I'm done.
so we're going to move on to questions now, okay? Also, okay, we may also have to pause for a camera reset. As you see, it's kind of not moving right now. So I'll let you know if that happens. But with that, we will go ahead and open it up to questions from members. I know you did answer one of my initial questions, which was how many licensed disseminators we have in Nevada. And did you state we had one?
We have one. We have one. We have actually two licensed disseminators, one who only does live broadcasts, and the other one that does what they colloquially refer to as the wire service, and acts as the hub for the off-track parimutuel system.
Okay.
The hub operator has told us in no uncertain terms that they're losing money and no longer want to be a hub operator.
Thank you for that. Just checking to see if we do have a question from Assemblymember Cole.
Thank you very much for the presentation and for the bill. I'm probably the only person in the building who actually understood what parimutuel betting was. My father.
Not necessarily.
Okay, well, that's
Yes,
good to know.
we had horse racing where I'm from.
I
Yeah.
love it. I love it. So I spent many, many times in my childhood at Charlestown down in West Virginia, and my father was a big member of Ladbrokes, so he did all of the off-track betting and stuff. But in any case, my one question is in Section 2, where we talk about in good faith and without malicious intent for that immunity portion. Can you just describe what malicious intent would look like? Thank you.
For the record, Mark Rubenstein with Reed Rubenstein and Bogatz. I'm not, I have to be honest, I'm not entirely sure the language was taken verbatim from Chapter 462, where a similar immunity provision exists protecting the state agencies. My belief is that it's an intent to do harm.
Okay. Okay, thank you for that. Right now, not seeing any additional questions, we'll go on and move on to testimony. We'll start here in Carson City with testimony in support of Senate Bill 203. Again, I ask that you state your name and spell it for the record, and please keep your comments to 2 minutes.
Good morning, Chair Miller, members of the committee. For the record, I'm Michael Alonso, A-L-O-N-S-O, and I'm here on behalf of Caesars Entertainment in support of SB 203. Keep this very brief. We're in support for all the reasons stated by the sponsor and the presenters. I want to thank Senator Pezzina for sponsoring the bill, and thank you, Chair Miller and committee, for hearing it. That's all I have. Thank you.
Thank you so much. Is there anyone else here in Carson City? Not seeing anyone. Is there anyone there in Las Vegas? Also not seeing anyone broadcasting. Please open the lines.
Chair, the public line is open and working. There are no callers at this time.
Thank you. Then I will open it up for opposition testimony, beginning here in Carson City. Not seeing anyone in Carson or Las Vegas broadcasting. Please open the lines.
The public line is open and working. There are no callers at this time.
Thank you. Then I will open it up for neutral testimony, beginning here in Carson City. I don't see anyone in Carson or Las Vegas. Will you please open the lines?
The public line is open and working. There are no callers at this time.
Thank you so much. With that, then, I will go ahead and welcome the senator back up for, okay. So they don't have any additional remarks to make, so I will go ahead and close the hearing on Senate Bill 203. Next, we have Senate Bill 256, which revises provisions relating to gaming. We do not have a presenter yet, so we will go ahead and pause for a few moments and wait for the senator to arrive. anymore. All right, we're going to go ahead and move on to Senate Bill 450. Senate Bill 450 revises provisions relating to bailiffs and deputy marshals in certain courts. Do we have presenters for Senate Bill 450? Right, because she wasn't made aware because we're waiting on Senator Nguyen, and it's... Senator Scheibel it was scheduled to go last, so. Oh, well, look at that. Wow, Senator Scheibel, you got that message. Yes, somebody was paying attention. Yes, it's true. No, it is not. That I know. But I am impressed with your, I barely said it and you were up here. Are you in committee right now, Senator? No, I am. And you are in committee? We are doing budget stuff. All right, let's go right now, Senator Nguyen. Thank you, Senator Scheibel. All right, so we will open the hearing on Senate Bill 256, which revises provisions relating to gaming. So your hearing is open. Whenever you are all settled, please remember to state your name and spell it correctly for the record, and then you may proceed.
Good morning, Chair Miller and members of the committee. My name is Rochelle Nguyen, Rochelle. Last name is Nguyen, pronounced Nguyen, and I represent Senate District 3 in Las Vegas, and I'm here this morning to present Assembly Bill 256, which revises provisions related to gaming, more specifically illegal gaming. The bill increases the criminal penalties for which a person is convicted of illegal gaming and would give the Nevada courts the ability to disgorge profits and any other benefit from illegal gambling proceeds in the state of Nevada. To provide some background and some general information on this topic, I would like to turn it over to my UNLV legislative intern, Cindy Mora, to provide additional testimony. Go ahead.
Thank you. Good morning, Chair Miller and members of the committee. For the record, my name is Cindy Mora, CindyMora, and I am an intern for Senator Rochelle Nguyen, and it is an honor to have the opportunity to present to you guys today. I want to highlight a crucial step forward in promoting fairness and integrity within the Nevada gaming industry by holding illegal online gaming apps and unauthorized sweepstakes sites accountable for unlawful gaming activities that target Nevada residents. This is a crucial issue that affects not only the credibility of our gaming regulation, but also consumers' protections and state revenues. As you all know, Nevada has a strict gaming law designed to maintain a fair and regulate industry. However, the rise of illegal online gaming apps and sweepstakes operators have seen an increased numbers of unlicensed platforms operating in the shadows, accepting illegal wagers, engaging in fraudulent practices, and profit outside the bounds of our regulatory framework. These bad actors not only undermine our illegal gaming industry, but also put consumers at risk. These bad actors not only regulate, don't pay taxes, and they don't provide any gambling protections to consumers. SB 256 directly targets illegal online gaming operations by implementing stronger penalties and financial consequences. It's done in three main ways. Number one, mandates disgorgement of profits. Any online gaming apps or sweepstakes operators found guilty of illegal gaming activities must forfeit all profits, gross receipts, or benefits obtained from these activities. That money will go directly to the state general fund. Disgorgement is also another tool the Nevada regulators will have at their disposal that will help deter bad actors from targeting Nevada residents. Second, it increases criminal penalties. The bill primarily adds disgorgement to the list of penalties that Nevada regulators already have, and it is increased the offenses of these companies that offer illegal gaming online from outside of the state of Nevada to Nevada residents from a misdemeanor to a gross misdemeanor. And lastly, it extends liability beyond the state's border. Even if an illegal gaming app operates outside of Nevada, it can still be prosecuted if its bets with the people within the state. This isn't about stopping online gaming. It's about making sure that it's done legally and fairly. Licensed gaming businesses follow the rules, pay taxes, and protect players. Illegal apps and sweepstakes operators don't. This bill ensures everyone plays by the same rules. Accountability is key. If an online gaming app engages in illegal activities, it should not be allowed to profit from it. This bill sends a clear message. If you operate illegally, you will be held accountable. By enforcing these rules, we protect Nevada gaming industry and the people who use it. Thank you.
Rochelle Wynn for the record. Chair, with your permission, we also have Darren Dorsey, the president and CEO of the Association of Gaming Equipment Manufacturers, to provide some more details on the specific provisions of the bill. And I see him in Las Vegas, so if I could turn it over to him with your permission, that would be our request.
Good morning, Chair Miller and members of the committee. For the record, I'm Darren Dorsey, D-O-R-S-E-Y, and as the Senator referenced, I serve as the President and CEO of the Association of Gaming Equipment Manufacturers, or AGEM. AGEM is a nonprofit international trade association that represents manufacturers, suppliers of electronic gaming devices, systems, table games, key components, and support products for the gaming industry. While AGEM is headquartered in Las Vegas and makes its home here in Nevada, its members represent the entire global gaming supplier sector that supplies gaming technology in all regulated and authorized gaming markets around the world. AGEM appreciates Senator Wynn sponsoring SB 256, and I'm happy to be here on this bill alongside the Senator and Cindy. AGEM and its members have a long history of supporting efforts to combat illegal and unlicensed gaming in this state, as well as every other commercial and tribal gaming jurisdiction across the United States and in regulated markets around the world. There are a significant number of large-scale operations of various types of illegal gaming sites, whether illegal sweepstakes or other forms of gambling activities, that continue to proliferate in states and countries abroad. AGEM and its members are proud participants in this regulated and licensed gaming framework, whether here in Nevada or across the globe, and we applaud these efforts in several states across the country to combat the various forms of illegal gaming activities. Whether it's our key AGEM members with brand names you recognize in Nevada like Light & Wonder, IGT, Aristocrat, Konami, to operators here in Nevada and elsewhere, our trade association friends at the American Gaming Association, the Resort Association, and so many other, the issue of illegal gambling hurts licensees and the public alike. Fortunately, the Nevada Gaming Control Act and the regulations of the Nevada Gaming Commission already prohibit these illegal gaming sites in Nevada. SB 256 is a straightforward bill that aims to add the penalty of disgorgement to the tools the Gaming Control Board already has to fight illegal gaming. We believe that makes sense, as the disgorgement of profits from illegal activity is yet another avenue that will help punish illegal operators who make such choices today. We also hope the enactment of SB 256 will discourage illegal gaming operators targeting Nevada residents in the first place. I'd also like to note for the record that we've had discussions with representatives of the Gaming Control Board regarding SB 256 and its language. We believe that the Gaming Control Board does not have any concerns with what SB 256 proposes to do. Cindy did a nice job of covering the provisions of the bill, and I can happily answer any questions you may have. But with that, thank you, Chair Miller and the committee, for the opportunity to be here today.
Rochelle Wynn for the record. Just to put it in layman's terms, I think a lot of times people are on their phones and they're scrolling through like Instagram or Facebook or any of these social media apps, and you'll see an ad that pops up that's like, hey, play solitary and you're going to make some money. You'll make $1,500 a month. If you've ever had the opportunity to unfortunately click on that, which a lot of like consumers do, and a lot of people that are on there, you're taken to an app that you download where you purchase gold coins, and it is essentially gaming. And it's illegal gaming. We had some questions in the Senate when I presented this on whether or not these penalties are these punishments. Why disgorgement? Why not like a restitution? Is this individuals? These are large entities or illegal corporate entities, and a lot of times overseas entities that are, putting these up to take advantage of some of these loopholes, and we think this will give the Gaming Control Board and the ability to shut them down and protect consumers here in our state and protect our industry. And with that, we are open for any questions you might have.
Okay, thank you so much. And thank you so much. Is this your first presentation, or did you present in the Senate as well?
Cindy for the record, and it's my second presentation.
Very nice. Thank you so much. With that, our first question is from Assemblymember Roth.
Thank you, Chair, and thank you so much for the presentation. My question is actually just in regards, it seems like there may be some jurisdictional issues if a lot of these companies are actually overseas. How many prosecutions have we seen under the current statutory framework?
I don't know if Rochelle Lynn for the record, I don't know if I have that information or if Mr. Dorsey might have that information, or if there is a representative from the gaming control, they might have an idea of how this is utilized. I know that they're not able to capture some of these people that we're trying to capture right now. But I do know that a lot of these are out of country, Russia, China, like other like areas that are doing this. Will this be the 100% solution? No, but it does give them another tool in the toolbox. So, Mr. Dorsey, I don't know if you have any of that data.
For the record, Darren Dorsey, and just to echo what the senator said, that is something, this is an additional tool in the toolbox because these are large-scale commercial entities, but adding this disgorgement might give an additional hook to grab on or further discourage that activity. But giving the number of prosecutions, I necessarily can't answer that, but it is difficult. This is more about adding some additional tools to the Gaming Control Board's box of things to discourage these activities, or maybe get something where there are assets or monies that might be captured somewhere else and give them a tool rather than a restitution tool.
Okay. Okay. Thank you. Our next question will be from Assemblymember LaRue Hatch.
Thank you so much, Chair, and thank you for being with us this morning. So my question is about the fine. I'm looking on page 2, subsection 3. There's a fine of $50,000 in comparison to the profits. I know that many times when we're talking about fines, illegal businesses will say, well, that's just the cost of business, and we're making $6 million a year, so it's not a big deal. I just wondered, what is the relationship of the profits in comparison to that $50,000 fine? Is it a huge gap?
Rochelle Wynn for the record. I think Mr. Dorsey might be in a better position to answer that. As he had indicated before, these are large-scale corporate entities, and so if they're making millions and millions of dollars, that's why the disgorgement we thought was so important, because if you find someone $50,000 and they're making $50 million, they will go with this fine every single day of the week. So I think the intent and the reason that we are going down that disgorgement is because it would be all of the profits from this illegal thing. And it would go into the general fund. It wouldn't go into any other but restricted account, I guess.
Darren Dorsey for the record, and just like the senator referenced, Assemblywoman LaRue Hatch, the issue is I think something that's important for the members of the committee to know is we see the size of the regulated industry today. The illegal industry is just as large or larger. So when you talk about a fine amount versus the profits that are being generated from those activities, it is exponentially larger than those fine amounts. But how getting into the weeds and the details of that specifically, do not know, but this is a better attachment to something that might otherwise discourage that activity rather than those more minor fine amounts that might be statutory or codified in $5,000, $10,000 amounts.
And so my question, I just want to clarify, because all throughout the bill, it says a person, a person, a person. So are we referring to a person as a person? It says a person who engages. As the person who clicks on that app or advertisement, not realizing, thinking that they're participating in, an online gaming. I understand there would be multiple ways to regulate and monitor companies and agencies and countries doing this. But does the person know that this is illegal? Is there a warning or something on that says this is illegal gambling, this is not permitted here? How does a person know this? 'Cause it also says willfully in the bill.
Rochelle Wynn for the record, and your legal committee counsel could probably clarify. We routinely refer to persons, and that can be corporate entities. So in my practice as a criminal defense lawyer, we routinely would have corporations and the heads of those corporations charged with like different various criminal like statutes. So I believe that is the intent on here. The real intent is actually protect that person or the actual person, the consumer that is clicking on this, thinking it is like a game that they can win money at, not realizing that it is an illegal game that people are playing. So that is the intention. That is how this currently works in practice. And adding this disgorgement is just, like you said, sometimes people might incorporate it into their, budget if it's a $5,000 or $10,000 or $50,000 or even $100,000 fee. And the disgorgement, I mean, that's real teeth in dissuading people from engaging in this.
Thank you. And I know we've had a lot of challenges because federally, it's been decided that a corporation is a person, but that's not something that we want. So if that's the case, that it comes after, that it's actually going after the businesses, corporations, and those entities.
Carly Okrent for the record. The term person is defined in NRS 0.039 for purposes of this provision, since a more specific definition hasn't been provided to include a natural person, any form of business or social organization.
So a person or business?
That's correct.
Okay. Thank you so much. Are there any additional questions? All right, Assemblymember Cole.
So my question is on the disgorgement. Is it just the disgorgement of profits that come from people inside of Nevada that are using this, or is it disgorgement of all profits for that entity?
Rochelle Wynn for the record. I'm not sure I know specifically on that, but I can get that information back to you after I talk to. It appears from the plain language of the text that it's disgorgement of all profits. So I think that is how I would read it. Obviously, if there is not an appetite to go after all the profits, we could make that distinction, I think, in the statute. But my reading of it is it does include all of the profits.
Okay, thank you. With that, I will go ahead and open it up for testimony. Starting first, here in Carson City, testimony in support of Senate Bill 256.
Good morning, Madam Chairman, Vice Chair, members of the committee. Virginia Valentine, Valentine, on behalf of the Nevada Resort Association. Just want to thank the bill sponsor, AGM, Mr. Dorsey, and especially the questions that you ask. I think it's really important, and especially Assemblyperson LaRue Hatch, the idea that the $50,000 penalty means nothing to someone who's possibly illegally gaining $50 million. It's really important. So we see this as a really important penalty and disincentive to illegal gaming in the state. So thank you again.
Good morning, Chair Miller and members of the committee. For the record, my name is Taylor Avery, Tayloravery, and I'm the Manager of Political Affairs for the Vegas Chamber. The Chamber is in support of SB 256, requiring illegally obtained gaming wins to be disgorged and sent to the State General Fund ensures those who break the law don't benefit from doing so. This bill aims to curb questionable so-called sweepstakes casinos, which pose a threat to consumers and the legal gaming industry. These operations, which operate in a legal gray area, deprive states of tax revenue, an outcome untenable for Nevada and its future. This legislation will ensure that those who gamble state gaming law lose big. Thank you.
Thank you so much. Is there anyone else here in Carson? Not seeing anyone here or in Las Vegas, I believe. Broadcasting, will you open the lines, please?
Chair, the public line is open and working. There are no callers at this time.
Thank you. Then I will open it up for opposition testimony, beginning here in Carson City. Not seeing anyone here in Carson or Las Vegas, I will go ahead and open the lines, please.
Chair, the public line is open and working. There are no callers at this time.
Okay, then I will open it up for neutral testimony. Is there anyone wishing to make neutral testimony? Not seeing anyone here or in Las Vegas, broadcasting, please open the lines.
The public line is open and working. There are no callers at this time.
Thank you. Then I will welcome Senator back up for any okay, there will be no final remarks. So with that, thank you so much. I will go ahead and close the Senate bill hearing on Senate Bill 256. Next up, we have Senate Bill 450. Senate Bill 450 revises provisions relating to bailiffs and deputy marshals in certain courts. And so Senator Scheibel, your bill hearing's open. Whenever you and your presenters are ready, please proceed.
Good morning, Assembly Judiciary Committee, and thank you so much for hearing SB 450 this morning. For the record, my name is Melanie Scheibel. I am the State Senator for District 9 in Southwest Las Vegas, and I'm joined today by Deputy Court Marshal Randy Hawks to present SB 450. I'd like to give kind of a general overview to understand what SB 450 is intended to do in practical terms. So if any of you have ever been in a courtroom to practice law or observe court, hopefully not as a defendant, then you know that the marshal or the bailiff is the person who keeps order in the court. That's the person in uniform who looks like a police officer and performs much of the same duties and obligations of a police officer to ensure not only that things run smoothly in the court, but to ensure safety within the courtroom. The way that a deputy marshal or a bailiff comes to be in that position in the courtroom is the subject of SB 450. Because they do not magically appear, they have to be hired, and they have to be appointed or assigned to a particular courtroom. So I think that the easiest way to kind of conceptualize what the purpose of SB 450 is to think about deputy marshals, and I'll use deputy marshals and bailiffs interchangeably because SB 450 really not really. It does only apply to Clark County because it's the only county with more than 700,000 residents, and we have deputy marshals down in Clark County. We could one day utilize bailiffs instead, but we'll say deputy marshals for simplicity. I think of a deputy marshal kind of like I think of our LAs, our legislative assistants or attachés. We all know that our LAs work for the Legislative Council Bureau. The Legislative Council Bureau signs their checks. The Legislative Council Bureau provides them with the paperwork to get enrolled in their health care plans. The Legislative Council Bureau sets their hours. They keep track of their vacation time and their sick time, and they are the ones who are responsible for those employees. At the same time, we all understand that our legislative assistant or attaché is assigned to us personally. They work only for us. They provide the necessary support that we need to do our jobs, and we get to set the parameters within reason of what they're going to do. Is our LA going to schedule meetings for us? Are they going to take meetings for us? Are they going to proactively call stakeholders, lobbyists, interested parties to set up those meetings? And we can choose exactly what we want our LA or attaché to do in order to support us. It should be similar for a deputy marshal or a bailiff, but unfortunately, in Clark County right now, there's not that clarity. Because in Clark County right now, the deputy marshals are hired by the county, they are paid by the county, their benefits are administered by the county, but they serve at the pleasure of the judicial officer. And so it is unclear who is in charge of making determinations about their vacation, about their sick leave, who they're supposed to report a grievance to if there is an unsafe working environment, whether or not a judicial officer is able to hire or fire a marshal. Because even though an individual judge might be unhappy with the performance of the marshal that's assigned to their courtroom, they are not the ones who signed the contract with the marshal. It was the county that signed the contract, and so how can the judge terminate the contract when they're not a party to it? The purpose of SB 450 is to clarify that confusion and specify in Section 1, subsection
2, subsection B, and then again in section 2 in a similar section, that the bailiff or the deputy marshal is a local government employee of the county. The purpose of this is not to erode the relationship between the judicial officer and the marshal. The purpose is not to tell a judicial officer that they cannot pick the marshal that they want assigned to them. Again, going back to my previous analogy, the way that we get to pick the legislative assistants or attachés who are assigned to us, the purpose here is to ensure that when it comes time for those marshals to interact with their human resources department, it is clear that they are employees of the county and not employees of the judicial officers themselves. And so I'll walk briefly through the bill and then I'll turn it over to Mr. Hawks to give some more context. Section 1 applies to the district court level marshals, and like I mentioned, it's that subsection 2, subsections A and B that clarify that the marshal is assigned to a particular courtroom, but they are a local employee. And then subsection 4 clarifies how vacancies will be addressed, that it is still a decision by the judicial officers as a whole to come to a consensus on hiring additional marshals. Subsection 5 does a couple of different things. In subsection B, it clarifies that the marshal is in charge of not just a seated jury, but also a prospective jury. So when the attorneys are conducting their voir dire, they're asking questions of potential jurors, the people who've been called in for jury duty. Sometimes that takes several days. And so when those members of the panel are still sitting in the box being asked questions by the judge, it's the marshal who will escort them outside, escort them back in, tell them where their seat is, things like that. I think it's just an oversight that it was previously only for seated members. It says attend upon the jury, which just wasn't clear whether that meant only after they were seated. Of course, the open and closed court. Subsection D, removing the performing other duties as may be required of him or her by the judge of the court, is actually an important provision, and I want to clarify what the purpose is of this here. Again, going back to my example, the way that we get to set the parameters for what our LAs and attachés do within reason, that is the purpose of subsection D, is to say that the county will develop the contract that describes the job duties of the marshal or the bailiff, and that the judges still absolutely have control over how their courtroom is run, the things that they ask and expect of their marshals, but that power is not unlimited. A judge can't send their marshal or their bailiff on, unless the county wants to put it in their contracts. They can't send their marshal on personal errands. They can't ask their marshal to do something that is unlawful. They can't ask their marshal to break county policies. The purpose here is to say that the marshals or the bailiffs have some protections within their contract, that they are expected to perform their job duties, which includes keeping the courtroom safe. They're not going to be asked to perform the functions of other jobs. That's another important point here. They're not going to be asked to step in for a recorder who is missing, for a victim advocate who is missing, for somebody else in the courtroom. Their duties are limited to keeping order and maintaining safety in the courtroom. And then finally, subsection 4 of subsection 5 removes a very antiquated provision that used to require the bailiff to place a bond before they took the job. So I don't know of any other job where you, except maybe being a partner law firm, but I just don't know of any other public employee who has to make a deposit with the employer before they get to start doing their job. And sections 6 and 7 make conforming changes. Section 8 or subsection 8 makes changes about, those are conforming, mostly conforming changes. Subsection A allows the bailiff or the deputy marshal to serve process on parties to lawsuits. And Subsection 10 maintains the requirement that they be a post-certified peace officer. And then Section 2, I will not bore you with repeating, that is the same language applying to the justice courts. So we're going to be treating district court marshals and justice court marshals the same. And with that, I'd like to turn it over to Mr. Hawks, who actually does this job and can explain a little bit of the history and purpose behind this bill.
Morning, Madam Chair, Assembly members. My name is Randy Hawks, RANDYHAWKES. I am the president of the Clark County Deputy Marshals Association. I am also a deputy marshal performing the duties in District Court 12 with Judge Michelle Levitt. It's hard to follow the senator because she covered everything very well. The provisions in 450 do not take away anything from the sitting judiciary as far as the trust that they have in the officer to protect them and the staff and the public that come into our facilities. Oh, I'm sorry. What it does do is set up what AB 139 lacked to do in 07, and that was put a principle in place when they removed the sheriff to then set the protocols so that they're evenly across every courtroom you walk into. The marshal would perform the duties identical to anywhere else in the building. Doesn't matter what courtroom he'd be assigned to or she. The protocols would be the same on how we handle things. We didn't want to overreach with this bill. We didn't address the duties portion of it because not only do we attend upon the prospective jurors and pick them up from jury services, we do attend on the seated panel, witnesses, media, everybody that comes into that courtroom. The public safety aspect of it, we needed to address because the judges, even though they are on the bench and control their courtrooms, their cases, and how they adjudicate and manage them, the public safety aspect of it and them being not through an academy, not police officers, and not understanding the safety protocols, and with them mandating them in each different department you go into, they're different. Unfortunately, thank God, Judge Holthus is okay and the officer that was in there, that was foreseeable and preventable. If we set the protocols as a law enforcement agency and mandate them through every courtroom and every facility that we as law enforcement protect, we can do a better job. And with that, if you have any questions or concerns, I am more than happy to address them.
Thank you so much. We will begin with questioning from Assemblymember Roth.
Thank you, Chair, and thank you for the presentation. Just for clarity, so in Washoe County, I know this does not address Washoe County. In Washoe County, we have bailiffs that are a department within the sheriff's office. And so they report to the sheriff's office. I think much like in your example of in LA, they manage the courtroom and safety of the courthouse, but report to the sheriff. I guess what I'm having a hard time grasping is what the current structure is under the court. And so are you saying that the current bailiffs under, at least in the 8th Judicial District Court, are not post-certified?
Randy Hawks for the record. No, Assemblymember Roth, we are all post-certified. Myself, I was hired prior to July 1st of 07 when the statute changed the requirement of a post-2 category to a post-1. So I'm grandfathered in. Every officer we have is post-certified and has to be post-certified. Our structure, we were under the sheriff until 1973. When the merger happened and Metro was formed, we were placed under the Office of Finance at Clark County. They maintained the hiring of the deputy sheriff bailiffs. In '07, AB 139 relieved the sheriff of his managerial responsibility and changed our name from deputy sheriff to deputy marshal. That bill failed to replace the sheriff and insert a new principal of the agency. So we currently have a director of security who manages there's a separation in our building between what they call judicial marshals and administrative. Administrative are not assigned to a particular courtroom. What they call judicial, and under the statute, they've taken it to mean that if the judge appoints you, you are now a judicial. The association has always taken the stance that appoint just means to the four corners of the courtroom. They can't appoint you to your position. You must go to an academy. If you fail to graduate the academy, you can't work for that judge. I am part of the administrative pool. I answer to the command staff. I am assigned to Judge Levitt and have been for the past 12 years.
Yeah. And Melanie Scheibel, if I could also weigh in here. I have predictably learned about this practicing in the 8th Judicial District, and it is, I think, very unusual. You have law enforcement officers without the structure of a law enforcement agency. And it is unlike any other agency I have ever seen, where, I mean, they do have ranks, they do have, deputy marshals and lieutenants and captains, but they do not have one chief law enforcement officer who is either appointed by the county or elected by the people. They sit in this very gray administrative area where some of them do report directly to a judge, and a judge who is not a certified peace officer has the final say on whether or not they are meeting their job standards and whether or not they want that person to continue in their role. And it also does create, and I don't know if this is where your follow-up is going, it does create issues with discipline and with ensuring continuity across courtrooms when you have certified law enforcement officers who are employed by this non-law enforcement agency. And this doesn't fully address it. We're not putting them back under the sheriff. We're not appointing a new law enforcement agency, but we are trying to clear up a little bit of that confusion to say that the county is the hiring agency for these law enforcement officers.
So Senator, though, wouldn't that be similar to like CCSD police that are actually employed by the school district and report to the superintendent?
Melanie Scheibel, for the record, but the CCSD police has one captain of the police department, and they have a law enforcement agency structure that allows for assignment of officers to different schools. And, I think it is also an apt comparison because we would not expect that the principal at a particular school would be able to hire and fire the police officers from CCSD police that's assigned to their school. We want them to have a relationship with those police officers, of course, and some continuity, but we would not want each school individually to be in charge of the police officers who are assigned to that school.
Well, they may not be in charge, but preferences are often considered. Okay, thank you for that. Do you still have a follow-up?
I do, if there's time.
Is it a follow-up to the line of questioning?
It is.
Okay, please proceed.
Thank you, Chair. And so what I'm just trying to drill down at is I don't see in the bill where it would put into practice actually having that structure in the county versus having a structure under the current system of being hired by the court.
Randy Hawks for the record. The court is not an employing entity. Under our state law, our state administrative code, the executive branch is the employing entity. In the separations of powers, Law enforcement has always been under the executive branch. We were as deputy sheriffs. When they changed it in '07 with AB 139, it created this ambiguity. Since then, the county has created the Office of Public Safety, which used to be the park police officers. So we already exist. They created the agency in '07 with AB 139. They just failed to place a principal of that agency to then set the structure, the command staff, disciplinary issues, how the grievances. The only way we can grieve something at this current time is to file a lawsuit under the statute. We are no longer under the county MPS with this MOU that the county and the court came up with. However, the county acknowledges in this MOU that I am a county employee. It has a provision for me to transfer anywhere within the county. There are things within the MOU that clearly identify that we are county employees. When I was originally hired as a deputy sheriff bailiff in '07, my ID was signed by the sheriff. I went to county orientation. My county benefit package, my paycheck, everything came from Clark County. It has only changed because the then Assistant County Manager, Jeff Wells, took the stance that AB 139 relieved the county of being our employer. And that's where the ambiguity came in. And I've been coming to the legislature now for 14 years to fix that problem. Cleaned up the language, we got rid of the ambiguity stuff and things that just haven't been done by practice.
Melanie Scheibel, for the record. Mr. Hawks is obviously more knowledgeable than I am in this space, and he understands the ins and outs of both the historical context and the current situation. Over the years that I've worked with Mr. Hawks, he has dumbed it down for me to understand that ensuring this subsection B on page 3, that the bailiff or deputy marshal shall be deemed a local government employee of the county, is the essential step one. We have to recognize them as local government employees of the county in order to get any of the rest of that stuff done that I was talking about with ensuring a law enforcement agency oversees this position.
Thank you for that. Our next question will be from Vice Chair Marzola.
Thank you, Chair. So I think I need you to dumb it down even more for me because I'm really confused. Okay, so your paycheck, does it state the county or does it state the 8th Judicial District Court? Right now.
Randy Hawks, for the record. Right this minute, it says the 8th Judicial District Court on it, effective of this MOU going in to effect July of 2022.
Okay, so since 2022. Okay.
Prior to that, everything said Clark County.
But from 2022 to today, it says 8th Judicial District Court.
Yes, ma'am.
Okay. If a bailiff gets in trouble or gets suspended, who carries out that suspension?
So there is current litigation for a 289 violation that Raimondo Enriquez filed against Clark County. The court intervened into that action. It went up to the Supreme Court on appeal, and we don't believe it's going to go any further based on the current decision out of the Supreme Court, which has been addressed in SB 279, clearly stating that the city cannot have a non-peace officer investigating peace officers, and therefore they ruled in the favor of the PPA on that case. We believe that the current litigation in Raimundo Enriquez's case is going to get dismissed, or I'm not sure the term, based on that decision. They'll render it mute or whatever because they've already ruled in it.
Okay.
So the only way for us to challenge or grievance a violation of our rights is to file a lawsuit. That's the only provision we have, because as of this MOU, we are no longer covered by the merit personnel system of the county. The court came up with an employee handbook, but it doesn't address grievances in there as it pertains to us, the officers.
Follow-up, Chair. Thank you. Okay, so I guess my question is, a bailiff gets in trouble, needs to get suspended. Who tells that bailiff that they're getting suspended? Is it the judge, or like who is it?
Well, that's where we're trying to clean this up with the statute change, is the ones that they consider judicials that are appointed,
Yes.
the judge has the final say on whether they get disciplined or not, or even investigated.
How about the
The
administrative?
administrative, we have an IA department that consists of 2 officers that conduct those investigations, interviews, and then the recommendation is made and it goes up. The court administrator has the final and sole say on what that discipline will be, whether it's, learn from this and move on, a written reprimand, a suspension, or termination.
Okay, so there is a process. Okay, Chair, my last question. Sure. Thank you. Do you guys have the right to collective bargain?
Randy Hawks for the record. The court has a court rule 1.53 that does not address specifically the marshals. We have been recognized by Roy Reed, the chair of the county commission, in 2010. We went to get our 3 dates, sit down on the first date. Then Assistant County Manager Jeff Wells walked in, said, "We're not going to collectively bargain with you," and walked out. We have been coming to the legislature and through different lawsuits tried to get this situation fixed. And that's why I'm back again today with this current bill to address this issue, to clean it up so that we can collectively bargain with our true employer that has always been Clark County. The judiciary and the court will still function as it always has. The judicial officer is going to get the marshal of their choosing assigned to their courtroom. We, the marshals, believe you have to have that trust of the judge that you're going to protect the public, the staff, and the judiciary in that setting. So we in no way have ever presented something that would take that ability away from them.
Thank you.
And if I could just add, Melanie Scheibel for the record, in June of 2024, the Marshals Association requested to be recognized by the 8th Judicial District Court as the bargaining unit for the marshals. And they received a letter back that I can submit to the committee as an exhibit from the assigned attorney general to the court, basically stating you can represent the administrative marshals, but not the judicial marshals.
Thank you so much for your responses. Thank you for your patience, Chair.
Thank you, Vice Chair. And yes, Senator, please submit that to the committee. We appreciate that. We will continue with a question from Assemblymember Gray.
Good morning, and thank you, Senator Scheibel. I understand what you're trying to do here, and I do appreciate it. As a former county commissioner, though, that body is not it's kind of a strange thing. They're more of a policy-setting body than any kind of an executive management agency. That authority is almost always delegated to the county manager. They're one employee. So I do have some issues with Section 1.4 that assigns the county commissioners the responsibility for filling vacancies for bailiffs. That is, wholly out of their purview. They would create the positions and authorize the positions, but never would they get involved in filling those positions, and I'm wondering why that's in there.
Randy Hawks for the record, sir. That provision was in the original statute from 1909. It has never changed. We We didn't change it because it's always been there. The county commission, if there was a vacancy that wasn't filled, I believe they told the county manager, hey, you have to fill this position. I don't think the county commission themselves held the interviews and filled it. I believe they directed the county manager to do it.
Melanie Scheibel, for the record. I agree. I think the language is a little bit antiquated, but the purpose is to say the county governance. And so the commissioners most likely through some kind of county manager and hiring system. It's a point well taken, though.
Okay, thank you. Our next question is from Assemblymember LaRue Hatch.
Thank you so much, Chair. So you mentioned that there is some confusion over whether you're county employees or judicial employees, and there was a mention that the county pays for everything and the county is in charge of HR, and I understand there's a lot of confusion about how judicial employees work, and my understanding is from Washoe. My understanding is that Washoe County gives money to Second Judicial, but then Second Judicial is basically in charge of everything from there. And so my question is, if you think there's confusion there, why are we carving out only the marshals? Wouldn't that confusion extend to every judicial employee if there is that confusion?
Melanie Scheibel, for the record, I think that the confusion is unique to the marshals. I think that the 8th Judicial District Court has been able to adequately define the roles and take on the administrative responsibilities for the other employees, the clerks, the secretaries, the recorders, those positions. I think they have been able to address, and because of the marshal's unique history, having been previously employees of the sheriff's department and then being transferred to the court and kind of the county, they do lie in this strange in between space.
So thank you so much, and thank you for the indulgence. I just wonder then, what is the struggle with not just adopting them to whatever the rules are that are governing everybody else that's reducing confusion? I guess what is the barrier there? Couldn't we just follow the model of every other employee of 8th Judicial that doesn't have that confusion?
The confusion, I think, stretches across every employee in the 8th Judicial District Court. However, we're only here to address the marshals. The SEIU represents some of the clerks. The newer clerks being hired in are non-union at will. So that I left to them to deal with. Us, the marshals specifically, everywhere else in our state, they are deputy sheriffs. We were until '07 with AB 139. So there was no confusion. The confusion came in when they relieved the sheriff of his managerial responsibility and Clark County took the stance that they no longer employed us. So it put us in this quagmire of who do we really answer to? How do we collectively bargain over benefits, pay, working conditions, things like that? It is Clark County. It always has been Clark County.
Okay, thank you so much. We're going to move on to a question from Assemblymember Cole.
I feel like I have 5 other questions now based on that, but I'm sticking with my original and just the one. So my question, and thank you, Chair. My question is in Section 1, Sub 8, where we're talking about the new duty of being able to serve civil or criminal process. So I guess my first question is, why the need to expand that duty? And is there any concern for, in doing so, that you create possibly an ethical violation, conflict of interest, if there's an issue with service of process and they have to become a witness in the courtroom? Thank you.
Randy Hawks for the record. This provision just cleans up the statute. We as peace officers in the state of Nevada, on any legal document, it clearly lines out the sheriff, the constable, any peace officer within the state of Nevada. We do not serve process in the courtroom. This is more of exterior. So if I have a warrant and somebody comes into the courtroom, I can execute that warrant. So we had a case recently where there was somebody in guardianship. The third party sent the warrant, said that that individual seeking guardianship had a warrant. It ended up being a different individual with the same name. However, because there were no protocols in place and it was the third party, that person was temporarily taken into custody on that warrant. So this gives us the ability to set parameters and better have checks and balances on how these warrants are administered. Not only that, but it's any process that, so in Clark County, the constables are kind of going away. So this provision, if at some point in the future, the marshals were to take over that duty, we wouldn't have to come back to the legislature to fix it again.
Melanie Scheibel, for the record, I don't know if I have permission to call on our council here, our committee council, but I think my confusion was with the crossed out language. It's very antiquated, and I think I know what it says, but I'm hoping that maybe a committee council can clarify what the change is by removing that, except such orders of the court which are specifically directed by the court, the presiding judge thereof, to him or her for service.
Carly O'Krent for the record. I apologize. Would you mind pointing me to the language?
Sorry, we're in subsection 8 of section 1. It's on page 4, around line 4, where we're striking out language about the process of service. It starts with accept such orders of the court, which are specifically directed by the court or the presiding judge thereof to him or her for service.
Carly O'Krent for the record, without looking at the legislative history to see what that language meant at the time it was adopted, I'm not sure I have much to add to that. I'm happy to follow up with the committee to let them know what the intent expressed on the record was during that hearing.
So I think part of that question is this actually an expansion? Because of what he just said, it sounded like they're actually serving process right now. And so that would be part of the answer that I'm looking for. Thank you.
Melanie Scheibel, for the record, I don't think it is a large expansion, if an expansion at all. I thought it was just kind of clarifying language. They're already able to serve both civil and criminal process, and I have read this struck through language multiple times trying to figure out what we were getting at, and I was very grateful to see it gone, so I don't have to deal with it anymore.
Thank you so much. And Assembly Member, if we have time at the end, once we go through the first round, I can return to you. There are other questions that weren't answered. We will move on to Assembly Member Gonzalez.
Thank you so much, Chair, and thank you so much for the presentation. There have been some recent news articles about bailiffs enforcing traffic stops, and so I was wondering if we could just clarify that and get that on the record. Is that part of your guys' duties? And if so, what are the parameters around that? Thank you.
Randy Hawks for the record. I know the article you are speaking of, and that is the City of Las Vegas City Marshals. That are not bailiffs or deputy marshals. It was a DUI on the freeway, and that was the City of Las Vegas. Had nothing to do with the deputy marshals, the bailiff, or the City of Las Vegas Muni Court marshals. It was the officers that handle all the city properties, city parks. It was those individuals.
Thank you. So just to clarify, may I have
asking for a follow-up, Assembly Member?
Yes, clarificating.
Are you asking for a follow-up?
Yes, may I have a follow-up,
quickly.
please? I just wanted to clarify because I didn't really get a yes or no on that.
Melanie Scheibel, for the record, correct. The deputy marshals we're talking about in this bill do not enforce traffic laws. We're not trying to allow them or ask them to enforce traffic laws.
You're welcome. And so I'd like to clarify, because I know in the presentation you mentioned this would be district and justice courts alike. So this measure pertains specifically only to county and not to the city at all.
Randy Hawks, for the record. Yes, ma'am. It only addresses the deputy marshals of the county. All the outlying justice courts as well as the district court.
Okay, thank you so much. We will move on to Assemblymember Urick.
Thank you, Chair, and thank you both for the presentation. Like my colleagues, this can get a little muddy and confusing, so I appreciate your efforts to try to bring clarity. And so as I am looking at this, it seems like the history of what happened with Metro, you were dissolved and back, but as it stands right now, as was addressed by our Vice Chair, it sounds like that where we stand today, the county is providing funding and resources to your employer right now that would be the 8th Judicial District, because that's who's issuing the checks, and ultimately, at least for those judicial marshals, are in charge of discipline and all of that. So with that, and by the way, Senator, I really appreciate your analogy and some of the challenges of like LCB staff, our LAs and attachés, but they report to us, so there is some. But here's the crux of my question. Is that all it lies within the legislative branch? And so instantly my mind went to, when I was reading this, of Article 3, Section 1, right? A separation of powers issue. And I remember there was a case, it was a while ago, but it dealt with municipal court situations with City of Sparks and the municipal courts. And so I went and pulled it, and it specifically references, okay, dealing obviously with municipalities, but it actually mentions marshals, and it talks specifically about how the court upheld the prohibition the city from interfering with the municipal court's ability to manage its employees, to enforce or enter in collective bargaining agreements, and all of that. So ultimately, my question is, how do we reconcile Article 3, Section 1, the Sparks opinion, and with what you're trying to do here, and how are we not running afoul of that separation of powers?
Randy Hawks, for the record. I've read the Sparks decision many times. That lawsuit was over 2 employees, the court administrator and the JEA, that the then sitting judge felt didn't need to take a 15% pay cut as every other city employee. The Sparks PPA never gave up representation of those officers because those officers are city officers. They are not hired by the court, they're hired by the city police department and assigned to the court. That's why in footnote 5, the Supreme Court declined to take up the issue of 288 and 289 as it pertained to them, because no employee was challenging employership, so they declined to take it up. They didn't give advisory opinions and left it alone.
Melanie Scheibel, for the record, if I could expand a little bit. I love this question because I think it really strikes at kind of like the heart of what we do as lawyers, debating the purpose of the Constitution and the 3 branches. And I think there is a distinction to be made between the separation of the branches in terms of their government functions and their daily activities, because you really can't have a judicial branch that is completely separate. Somebody has to build the building. Somebody has to build the parking structure. Somebody has to ensure that the lights are on for people to enter and exit the courthouse. And that's how I think of the marshal's role, is more in that day-to-day function. We're not trying to tell judges how the judicial branch is supposed to rule on a case. We're not trying to tell them what kinds of cases they have the power to hear and not hear. We're trying to say that where the county, the executive branch, is responsible for providing services to the judicial branch so that they can do their job, one of those services, if you will, is security. And I think that both models work. A model works where the security is completely insular and those individuals are hired directly by the judges, they're hired directly by the court. But if the court is not going to take on all of the roles and responsibilities of that hiring, firing, discipline, benefits, HR, and they're going to outsource that to the county, now the county's involved. And so I think that we're trying to ensure that for those particular roles that are not unique to the judiciary, we're not talking about making decisions on laws, we're not talking about interpreting the Constitution, we're talking about, telling people that they have to be quiet and that they can't threaten somebody on the record. We're telling people that, you have to wait outside the door until the door is unlocked. We're telling people they have to sit down in the courtroom, those kinds of things that a marshal does. And I'm not trying to diminish the role of the marshal. I'm just trying to distinguish between, they're not a judicial officer. They are there for public safety. And if they could be employed by the sheriff's department, then certainly they can be employed by the county.
Thank you so much for that explanation, and certainly it is the privy of, it's what attorneys do, right? We look and we try to find these issues. And I guess the follow-up question is for Mr. Hoxton. You had alluded to some pending litigation. Is this the subject, this issue that we're talking about, the subject of any of the pending litigation that's before the Supreme Court or any other court right now?
Randy Hawks for the record. I don't have that particular lawsuit in front of me. I believe it is addressing the violation of the 289 rights. And that's been addressed in the latest Supreme Court decision that come out, as well as SB 279 that is working its way through the system now, that took the language from that decision and put it into the statute to clarify how notice has to be given, who can do the investigation, who can conduct the interviews, the hearings, and all of that. So I think the Supreme Court will not issue oral argument on that case. I think they will dispose of it based on their ruling in the City of Las Vegas PPA case.
Thank you so much. We have a question from Assemblymember Hanson.
Thank you, Chair. And it's good to see you, Senator Scheibel, and hello, Mr. Hawks. My question is really going to try to help me understand the use of some wording in Section 1, Sub 1B, which you mentioned earlier. Each bailiff or deputy marshal shall be deemed, and with emphasis on the word deemed, that's what I need clarification on, a local government employee of the county. So how does that differ when we say deemed a county employee? How does that differ from being hired, managed, or overseen by the county?
Randy Hawks for the record. I am not sure because the language came out of the LCB, so I don't know why they used the word deemed.
Melanie Scheibel for the record. I think part of the reason is that this addresses employees who already are hired and they already are working. And so to deem them county employees would be to now classify them as county employees.
Assemblymember Delia, did you have a question? No? Okay. Assemblymember Cole?
Thank you, Chair. Appreciate that. So this goes back to the collective bargaining situation that we were talking about. We were sort of bouncing around in different questions. So what I think I heard was that the administrative marshals can currently collectively bargain with the 8th Judicial District, and the judicial marshals can collectively bargain with the county. Is that accurate?
Randy Hawks for the record. No, ma'am. We sat down and sought collective bargaining through Court Rule 1.53. However, what we were met with was unattainable.
And when you say we, do you mean the administrative marshals or the judicial or both?
Both. I represent both judicial and administrative as the president of the association.
So, Melanie Scheibel, for the record, at this point, no entity is recognizing the Clark County Deputy Marshals Association, CCDMA, as the collective bargaining unit. Both the county and the court are declining to recognize them as a bargaining unit.
Do you
Do you,
think the
are you
issue
asking
could-
for a follow-up?
Yes, sorry, yes, thank you.
Proceed.
So I guess my question then becomes, is there potential to rectify the situation with collective bargaining to make two associations, one for the judicial and one for the administrative? And then that fixes it.
Melanie Scheibel, for the record, I think the goal is not to do that. The goal is to have one association for all of the marshals that the county, to be frank, that the county would then recognize as a collective bargaining unit. And of course, I can't control whether or not the county does that, but that is why, we're coming full circle to Assemblymember Roth's initial question. This is like not a complete fix, but step one is, let's all agree, they're employees of the county, and that is a step towards ensuring collective bargaining with the county.
And Randy Hawks, for the record, the county has 150 positions countywide for deputy marshal. The only separation happens when you get to the court. So many positions for district court, so many positions for justice court, the outlying areas, and then a even further division of, if you fall under the word appoint within the current statute, you are then a judicial instead of an administrative. So by putting us back clearly under the county as our employer, there's 150 positions. There is no separation of the marshals as far as administrative or judicial.
Thank you. We have a question from Assemblymember Hardy.
Thank you, Chair. So I've just been listening and sorting all this out as everyone else is here. And I did spend a significant amount of time working in the 8th Judicial District Court and Justice Court, and, specifically for judges, and saw their interaction with their bailiff, as we called them. And so I'm just trying to understand, like, administrative bailiffs, the ones, we go into the courtroom, they man like the security, like we have here, but then and move throughout the courthouse, and then you have the ones assigned, as you're saying, to a judge. So I'm just, like our legislative council bureau here kind of manages our legislative police, and so I'm just trying, I feel like some of this is taking a little bit of judicial discretion away, specifically to the a judge's bailiff, because I know how close those relationships were, and to me, some of those bailiffs were with those judges until they retired. I mean, 25 years. So I'm just trying to wrap my head around. It feels to me like specifically for those, we're taking away some discretion for that judge. Specifically, you mentioned like, disciplining them and stuff like, so I'm having a hard time with that specifically.
Randy Hawks, for the record. So currently, we have a policy and procedure manual. The appointed judicial marshals are not held accountable to that, okay? And when they are, the judge has the final say in their discipline. We're saying that the judiciary are not qualified because they don't understand the parameters of the law enforcement portion of it. And in no way are we detracting from the ability of a judicial officer to have the marshal of their choosing assigned to their courtroom. I've been assigned to Judge Levitt for 12 years. She only wants me in the courtroom. However, when I'm on vacation or like coming here today to be in front of you, the administrative marshals fill those voids. However, because we're short-staffed, we have the critical labor shortage that gets renewed and other stuff, we don't have the ability to draw from what they call judicial marshals because they don't answer to administration. So if I have a judicial marshal that doesn't have anything going on in their courtroom, I can't ask them or mandate to them as a command officer, I need you to go cover a different courtroom. I can't utilize that body. And that's a problem for us. We're trying to get fully staffed. However, we have the critical labor shortage. We hire officers, they go to other places because Clark County placed all of my officers under civilian PERS and not police fire where we belong. And because we can't get a collective bargaining agreement with Clark County because of the inadequacies of the statute currently, we sit in limbo over pay, benefits, working conditions, and having a say in the policy and procedure manual. So that's what we're trying to fix. In no way will the judicial officer lose that ability to have trust in that relationship with the officer that they want.
I understand that where you're coming from, but it's still kind of muddy for me regarding that. And I'm just, like I said, LCB oversees our legislative police and they're not peace officers. I mean, and just to say that a judge can't oversee that person, I don't know, I'm just struggling with trying to parse this all out.
Melanie Shiloh, if I could weigh in, I think I do understand what you're saying, and it is a policy choice. And I don't want to shy away from the fact that we're making a policy choice by saying that the marshals are county employees as opposed to direct employees of judges. And just kind of speaking personally on how I came around on this question is that, I think of the great judges that I work with who have excellent relationships with their marshals, and it is incredibly important that a judge feels safe on the bench and have a marshal who they can trust. And just like, again, us with our LAs and attaches, and that relationship is, 120 days, not, 12 years. And I think this is not designed to, and it does not have to erode that. And unfortunately, we also have to remember that there are some bad actors too. And so, I think there are also judges who have created bad working environments for marshals. And so then I think about those marshals who took on this role, maybe under one judge who didn't get reelected and got assigned to a new judge. And I want that marshal to have the ability to speak up and get reassigned if that's what they need, to be able to speak up and have a change in their working conditions. And so that to me was sort of the balance to be struck, was to think about both, the good actors and bad actors on both sides. And I think that this will be a step in the right direction to ensure that we don't take away the ability for judges to develop trusting relationships with marshals. And we also give deputy marshals they're a little bit more empowered to demand good working conditions.
Thank you so much for that. We have one final question from Assemblymember Gray.
Again, I really appreciate what you guys are trying to do here, but to tag on to my colleague, about the waters being muddied here, why don't you guys just create a marshal position, a chief marshal position, put them all under him, and he answers to the county manager, and it clears up so much of that ambiguity. He could be the liaison to the judges, and everybody could be, could live happily ever after.
That's what our intent behind this change is, so that when we go to collectively bargain with Clark County for the marshals as a whole, part of that command structure that'll be set up will be a chief marshal that we answer to. He will be answering to the county manager or assistant county manager, wherever he's placed, but he will be a liaison to the chief judge as far as when a new judicial officer comes in, an existing one has a problem with their marshal, they can tell him they want to select somebody new. Currently, if a marshal is removed from an appointed position, the court administrator has the final say on whether or not he goes back to the pool of available officers or he's just let go. there is no due process. And that's what I'm trying to fix with this statute change is the collective bargaining agreement, the due process, because as we all know, if you get let go from one law enforcement position, nobody else is going to touch you.
All right, thank you so much. We will go ahead and open it up for testimony. Thank you for responding to our questions. Starting with support testimony here in Carson City on Senate Bill 450.
Good morning, Chair and Committee, and thank you. My name is Joshua Skaggs, and I'm the Legislative Affairs Director for the Nevada Republican Party here in support of SB 450. SB 450 acknowledges the executive branch's role in managing law enforcement, which includes ensuring public safety within courtrooms. By allowing deputy marshals to operate under the jurisdiction of the county, SB 450 aligns with the executive branch's responsibility for law enforcement while respecting the judiciary's inherent authority to manage and adjudicate cases and not be burdened by the requirement to also mandate security protocols at courtrooms and courthouses. This collaboration enhances public safety in courtrooms, ensuring that law enforcement personnel are effectively positioned to maintain order and security during judicial proceedings. Please vote yes and support SB 450. Thank you.
Thank you so much. Is there anyone else here in Carson that would like to testify in support? Not seeing anyone. Is there anyone there in Las Vegas who would like to testify in support? Also not seeing anyone. Broadcasting, will you open the lines, please?
The public lines are open and working. There are no callers at this time.
Thank you. Then I will open it up for opposition testimony, beginning here in Carson City.
Thank you, Chairman. For the record, Jason Frierson on behalf of Cornerstone Group and 8th
Please
Judicial
spell your
District,
name.
Frierson. I appreciate the opportunity. We are here to testify in opposition. I do want to note, I think that the endeavor to create uniformity is an intellectually honest effort. It makes sense when you think about it intellectually, but in a practical sense, no courtroom is created equal. No courtroom operates the same. No judge in particular operates exactly the same. No judge has the same hours. Criminal, civil, family, different judges have different practices, similar to your attaches. Not a single one of your attaches I can attest to operates exactly the same. As much as we would like to have uniformity, that just doesn't work in a practical sense. And so I wanted to I think clarify to the extent that I can. In a courtroom, you have administrative marshals and one judicial marshal if that judge decides to select one. That one judicially selected marshal answers to the judge currently, and again, they have different needs, different priorities, different preferences, and then the rest are administrative judges. They all are county employees, but it's akin to a political appointment. And so almost every judge has opted to select a marshal for their courtroom and for their safety. Not everyone has, almost all of them have, but it's an optional thing. It is an appointment that a marshal can accept or decline. If they choose to decline it, they can stay in the pool of administrative marshals and be treated as such and fall under the MOU that the county has created, which allows for collective bargaining. So it's not an effort to prevent collective bargaining in that sense, but for the politically appointed marshal, that person is agreeing to answer to that judge. And so I say it's an honest endeavor because it makes sense, but the judges need to know that their safety and security is their number one priority. But after all of that, I think it's really important to point out that there is a current case dealing with this exact issue, and I think it's a dangerous precedent to resolve a pending case through the legislative process.
Thank you so much.
Good morning, Chair Miller, members of the committee. Alex Ortiz here representing Clark County. After listening to some of this discussion, I hope that my prepared remarks will be able to address some of these questions as well. SB 450 seeks to reclassify deputy marshals as employees of Clark County rather than employees of the court as they are today. This bill originates from ongoing litigation between the deputy marshals and the court, and Clark County opposes it because it both is confusing and unnecessary. Both the court and county have long agreed that deputy marshals are employees of the court. There has never been confusion on this point from our perspective. The court is responsible for hiring, setting compensation, managing terms of employment, and disciplining or terminating marshals. The county's role is limited to funding the courts, not managing the court personnel. This bill introduces ambiguity into what has been a clear employment structure. For instance, it states that marshals will be deemed, quote, deemed, local government employees, yet still hired by judges. The term deemed is vague in this context, and the practical implications are unclear. A person is either an employee of the court or employee of the county, not a hybrid. They must answer to one employee's policies and directives, not two. Blurring this line creates real confusion over supervision and job responsibilities, which could lead to more litigation among the marshals, the court, and the county. More importantly, the marshals are tasked with protecting judges, court staff, and the public. Any uncertainty about who directs and supervises them could jeopardize safety in our courthouse. This is not a risk that we should take. Additionally, SB 450 introduces an unusual provision requiring the Board of County Commissioners to hire deputy marshals under certain circumstances. This is not an appropriate role for the board. Reviewing individual marshal candidates in open meetings and voting publicly on hiring decisions is not how law enforcement hiring works anywhere else in this state, and it sets a concerning precedent. One thing, too, I want to bring in. Yes. Did I reach 2 minutes?
Yeah, you're 2 minutes.
I'm so sorry. Okay, well,
thanks.
I appreciate your time. Thank you.
Thank you so much. And if you have any additional comments, you can submit those to members in the committee as well.
Okay.
Thank you so much. With that, is there anyone else here in Carson City in opposition? Okay, Judge, we see you down there in Las Vegas. Welcome to Assembly Judiciary, and please proceed when you're ready.
Good morning, Chair Miller and members of the committee. My name is Jessica Goody, Goodey. I'm a judge with the Las Vegas Justice Court, and I am vice president of the Nevada Judges of Limited Jurisdiction, which is our statewide association of the Justice Court and Municipal Court judges. I'm also testifying in opposition on behalf of the Las Vegas Justice Court as well as the NJLJ. I echo the concerns of the 8th Judicial District as well as the written comments submitted by Henderson Justice Court. I would note that there are differences between sections 1 and 2 of the bill and how they're treating district court marshals versus justice court marshals. And I do want to clarify there are some differences apparently in the structure of our marshals. For example, in justice court, we do have a chief marshal over our justice court marshals. That chief is responsible for the administrative supervision of both judicial and our administrative marshals, whereas the daily management of my judicial marshal falls under me. But we work together to have that work in a very efficient manner. SB 450 does, in fact, get rid of my ability to select, manage, and supervise my marshal. It indicates that the marshals will be assigned, and the only entity it gives the ability to assign is the Board of County Commissioners. It doesn't give us any sort of criteria as to how those assignments would be made or how often it could be changed. So I could walk into court every day with a different marshal. As many members of the committee have pointed out, that leads to a significant public safety issue as well as judicial safety. Attacks on the judiciary are at an all-time high, and that is something of prime importance. Probably getting close to my 2 minutes. I will be submitting written comments to address some of these further issues, but I will note that we do also have a concern with the expansion of powers and allowing the marshals to serve civil and criminal process and the conflicts of interest that it could rise. Right now, my marshal can serve process as I direct him to. Under the new bill, it would allow him to serve in any civil or criminal case, which would obviously lead to a potential conflict of interest. Thank you for your time and consideration.
Thank you, and you made it with 2 seconds to spare, so thank you so much. Is there anyone else down there in Las Vegas that would like to testify in opposition? Not seeing any. Broadcasting, will you open the lines, please?
The public line is open and working. There are no callers at this time.
Thank you. Then I will go ahead and open it up for neutral testimony, beginning here in Carson City. Not seeing any. I don't see anyone there in Las Vegas, I believe, either. Broadcasting, will you open the lines, please?
The public lines are open and working. There are no callers at this time.
Thank you so much. Then I will welcome the bill sponsors up for any final remarks.
Thank you so much, Assembly Judiciary. Melanie Scheibel for the record. I just wanted to mention that I'm happy to work with the opposition on their concerns if there are things that can be addressed. I'm not sure that they are, to be frank, but I did want to make sure that they were aware of that and you were aware of that. And the only other thing I wanted to mention that came up in opposition is that I agree it is a bad precedent to resolve ongoing litigation by passing laws. In this particular space, I think there has been ongoing litigation for the better part of 20 years. So, I mean, waiting until litigation is over is just not really realistic. And I think at some point you say, okay, this has come up so many times that the legislature does need to step in and make a decision. And I think that we're at that point.
Randy Hawks for the record, Madam Chair. I'm doing what I was directed to do by the Nevada Supreme Court in one of our cases. They said it was too much of a complex issue. The legislature needed to fix it. I've been coming here for the past 14 years to try and fix this. I implore you to pass this bill. We are more than willing to work with them on their oppositions and the things that they think are ambiguity in the statute. However, this statute change does not detract from any of the judiciary having assigned the marshal of their choosing. Instead of they may appoint, they may have assigned. So it addresses any concern that they won't get the same marshal. I've been assigned to Judge Levitt in a criminal courtroom. We do murders, we do all high-profile cases for the past 12 years. She does not have any issues with the thought of her safety, the staff's safety, or the public that comes into that courtroom. By allowing these judges to mandate the safety protocols, we've had a marshal have his neck and back injured and end his career. Currently, we were an SNL joke, which is appalling to me. One of my officers had his head filleted open, and Judge Holthus was attacked viciously. That was foreseeable and preventable by the marshals, the law enforcement entity, taking control and setting the safety protocols across the board so that every department knows they will be protected. Thank you.
Thank you so much. And with that, I will go ahead and close the hearing on Senate Bill 450. The last item we have on our agenda today is public comment. Again, public comment is not for remarks made on bills that were heard today, but for anything else under the purview of this committee. So I invite anyone up who would like, beginning here in Carson City, who would like to make public comment. Not seeing anyone. Is there anyone in Las Vegas that would like to make public comment? Also not seeing anyone. Broadcasting, will you please open the lines?
The public lines are open and working. There are no callers for public comment at this time.
Okay, thank you so much. With that, then, we will go ahead and close public comment and adjourn for today. And with that, I believe we'll try it again. We may start at 8:30 a.m. tomorrow morning. So I will see you all tomorrow morning. Thank you, committee members. Thank you. Committee members, I'm sorry, can we change that? I will reopen this committee meeting. We have to meet at 8 a.m. because we have committee pictures at 7:45 a.m. So everyone needs to, it's 7:30? Oh my God. Does anyone really want a picture tomorrow? Okay, we will see you all at 7:30 tomorrow. So 7:30, and we will begin committee at 8.